Okay, so what is the Office of Technology and Licensing? What is our mission? So our mission is to promote the transfer of Stanford technology for society's use and benefit while generating unrestricted income to support research and education. And we're doing this with about 50 people or so, and 15 of which are devoted to helping with licensing and stuff like that. And when we say technology here, what we're really referring to are things like inventions. So if you were to come up with a cure for cancer or any novel or new devices or processes, that would be an invention, or works of authorship, such as a drawing or diagram or any reports that you come up with during your research. And then we're also talking about tangible research, tangible research sorry, I'm blanking. Tangible research products such as like mice or cell lines, and then other information and data that you develop during your research. And Sunita will actually talk more about the income portion later on. Okay, and with that, I think Lisa is going to talk a bit about the organization chart at OTL.
Yes, thanks, Ian. I've been at Stanford for almost 5 years, and I think one of the things that confused me a lot early on is how we are organized, not just within OTL, but just sort of the entire organization. OTL, Office of Technology Licensing, sits actually under the Dean of Research's organizational arm here at Stanford. And within OTL, which is headed by our executive director, Karen Irmer-Gluck, there are numerous groups here. As you can see from this slide, there's the licensing group, there's IP management, strategic alliances, which is what Sunita heads up, business development and marketing, which is headed by Yingli Chen, who is, I think, also on this in this presentation, but she's our director of BD and marketing. There's the High Potential Innovations Translation Fund, also known as HIT, which is an internal Stanford proof of concept fund that is, just starting up again. So if there's any interest in that, please let us know, so that I believe Sunita told me that we are hiring for a position there. And then also there's the Industrial Contracts Office, which both myself and Ian sit within. And then there's our business operations and accounting. And the latter, the business operations and accounting, they have a monumental task of tracking all of the royalties and income that Stanford generates from these inventions and technology that come from our fabulous researchers. So I think that's it on my end. Ian, you want to go to the next slide and you'll take this.
Okay, thank you. Yeah, so let's talk a little bit about the types of agreements that ICO specifically handles. However, before we do that, I want to shamelessly plug our website, which is at the link below. And on that website, we do have some additional information about these types of agreements. We also have some additional information about ICO generally, and then that's where you can find a link to our intake form, which is where you can submit your agreements for us to review. And that intake form also asks additional questions about the research project, and that just helps us provide a thorough review of the agreement. So we handled about 2,000 research-related agreements last year, all of which these are, including about 400 sponsored research agreements. And we deal with agreements between Stanford and industry, with one exception, and that's really in the realm of material transfer agreements and human material transfer agreements, where we also put those in place between Stanford and other nonprofits and universities, and also the government. And I'd say that out of all of these, the most common that we deal with would be the material transfer and human material transfer agreements. So generally speaking, as a general premise, Stanford wants to own the technology that it develops or the results that it develops. So for instance, in a material transfer agreement, let's say that UCSF is providing Stanford with some mice. UCSF, they own those mice. They can control what happens with those mice. They can restrict how we use the mice. and they typically do that in the agreements that we deal with. So let's say we've received these mice, and as part of our research, we end up we modify them or we improve them. Let's say we genetically modify them. So a question arises of, who owns that improvement or who owns the modification, and that's something that Stanford should own, and often is a point of negotiation in some of our agreements, especially with the industry or for-profit entities. But that's, generally speaking, that's kind of how we view intellectual property in these research-related agreements. So for instance, in sponsored research agreements, where a corporation is providing us funding to do a specific scope of work, we would want to own the technology that we developed during that project and also the results. And this allows us freedom to use any inventions that we come up with during the research. This also allows us to own any samples that we collect during the research. And really, this ownership gives us the control and the freedom to operate and the freedom to conduct further research in that field using that technology and those results, including collaboration with other academic institutions. Whereas if we didn't actually own the materials or the results or the technology, we might be limited by the owner. So, and I know there was a question about non-disclosure agreements, I think in the email leading up to this presentation. So I wanted to briefly touch on those as well. So non-disclosure agreements typically arise when a company wants to talk with one of our faculty members to see basically whether it's worthwhile to enter into a future collaboration or sponsored project or provide funding to us. And as part of that, they need to send our faculty member something that they want to kind of keep secret from the rest of the world. So these agreements will protect how we can, or prevent us from using that secret or confidential information, and gives them the protection they want so that they can discuss with our faculty member whether a collaboration or sponsored research project is worth entering into. And one thing to note here is that ICO, while we can help advise on these agreements, if it's just another entity sending us confidential information, the faculty member actually would be signing it, and Stanford would not be a signatory to that. However, if we are sending any confidential information or any Stanford technology or proprietary information, as part of it, we need to be involved because Stanford would need to be a signatory to the agreement. And with that, I'll go to the next slide. So very briefly, I just want to talk about our process flow. As mentioned on the previous slide, our website has a link to the intake form, which is where you can submit agreements for us to review. So if you need us to create or draft an agreement as well, that's how you would do it. And once we receive the intake form, we'll take a look at it and draft or review and negotiate any agreements we need with the other party to get those in place. And then once it's finalized, we will sign on behalf of Stanford. One thing to note here, faculty and students do not have the authority to sign on behalf of Stanford. It needs to be an institutional official with the appropriate authority. So if you see something that requires a Stanford signature and it's with a for-profit corporation, reach out to us and we can help with that agreement. So let's say we got the agreement all set and the project's moving forward, and hey, we need to extend the time period in which we're doing the project, or we're getting more funding, or we need to change the scope of work. We can also help there. So please reach out through our intake process and we'll draft and sign an amendment to the agreement to make sure the research continues. Okay, and then lastly, I kind of want to talk about some of the other Stanford resources out there that can provide assistance to you here at Stanford, depending on the circumstances. And also, I want to point you to the link at the bottom of this page here, which is a resource that can help you decide where your agreement should go and which office should review it. So feel free to take a look at that as it can be very helpful. And I'll just touch on two of these before passing it over to Sunita to talk more about licensing and patents. But the Research Management Group, RMG, they'll likely be your first stop for most projects because they help to develop budgets and proposals for all of the School of Medicine for sponsored research projects. And then they also handle basic grant awards and fellowships. And now, lastly, I'll kind of talk about licensing. And usually they'll come in at the end of a project after an invention has been disclosed, and they'll come in and be able to help with commercial licensing agreements going away from Stanford to another entity, or with confidential and non-disclosure agreements regarding inventions. And with that, I'll pass it to Sunita for the next slide.
Great, thank you. Thank you, everyone. So as Ian and Allison said before, I joined Stanford in December 2019, and most of my experience in tech transfer is from UCSF. I was a bench scientist there for a few years, and then decided that I was very interested in translational activities and being part of taking technology from the university to the industry and see how products are made. So that's when I switched to tech transfer. And I thought this is my perspective. I just wanted to clarify, as I talk about IP and patents, I'm not a patent attorney, but from our perspective, how I have learned to evaluate inventions over the years. So what is tech transfer? So in simplest form, technology transfer is moving the technology from a person or organization that holds it or owns it to another organization or a person, right? So you are doing that every day through publications, conferences, graduate students, when they graduate, they take what they learn here to another institution or to industry. We allow faculty to consult. There's internships, but what we would be focusing, or what OTL focuses on, is the collaboration, sponsored research, and licensing. So those are the primary forms of technology transfer that we deal with. Next. So why do we do it? And I would say my main answer is primarily because of the impact that university research makes on the world. It's not always about the money. So this slide shows you some of the life-improving blockbuster products and technologies that have come out of university research. So if we didn't have that, I mean, there are some really important drugs. Everyone knows here about Google that came from Stanford, and that made our life easier in terms of searching for our queries on the earth. But anyway, that's the main reason why universities focus so much of their efforts on tech transfer, for making impact in the world. Next slide. So what is the tech transfer life cycle? It begins with your brilliant research. These are the numbers for Stanford, actually. So the process starts with the research in your labs. In 2019-20 cycle, $1.93 billion came to Stanford for research. 75% of that actually was from the government sources, and rest was from other sources, industry, sponsored research agreement, as well as gifts and other funds. So once you do the research, it leads to invention disclosure that comes to our office. We then assess the disclosure and see what should we do with it. And we'll go through some of the ways we can protect the IP or commercialize the IP without even filing a patent. So then if it makes sense, we file a patent application. In 2020, we received 595 invention disclosures, and we filed 432 new patent applications. Then the next step for us is to find a company that's going to take that technology, because Stanford is not a commercial entity, so we don't commercialize technologies. Then Yingli and her excellent team they are constantly building relationships with the industry to find out what their needs are. And whenever we think we have an appropriate technology for them, we share with them. And then it's the process of selecting a licensee. Is the licensee appropriate? Do they have resources and expertise to take the technology forward? Because we don't want someone to license our technology and shelve it because they have something similar that they're working on, and they think that we want to avoid competition. We don't want that. We want them to take the technology and really develop it for public benefit. So once the technology is commercialized, it leads to royalties for the office. In 2020, the OTL received 119 millions, which is actually towards the high range, where we had a couple of companies that went public or were acquired, so that led to high income. And we'll talk about how the income is distributed within Stanford. Next slide. So what is intellectual property? So intellectual property is really any original product of human intellect. It could be artistic, literary, technical, or scientific creation. And intellectual property rights are referred to the legal protection that's provided to creators or inventors against unauthorized use by others for a limited time. It's an incentive for them to create more, because they can use this to commercialize and to sell the IP, and that way they get rewarded. So I think we would all agree that intellectual property protection is critical to fostering innovation. So think of all the life-saving drugs, agriculture products, alternate energy. You couldn't incentivize companies to invest into the development if they weren't able to recoup their investment and make some profit, right? For a drug these days, it takes almost $1 billion to take the drug, a molecule, from research to the actual clinic. And I think if the company didn't have the rights to exclude others from making that drug, there would be no incentive for them to invest into that. Next slide. So Ian had referred to that, different types of IP before, but primarily we would be focusing on patents. So patents protect inventions. Invention is basically anything that's useful for its intended purpose, that solves a real world problem. It is the most powerful and expensive way of protecting your IP. Then you have copyrights, which basically protect expression of ideas that are fixed in tangible medium, like a book or an article or video. The copyright owner gets rights to produce, make, display, and if anyone else wants to do it, they need copyright owner's right. You get automatic right as soon as you write something on a paper or you draw something on a paper. But if you really wanted to go and litigate someone from misusing your copyright, you would need to register that. And the lifetime of copyright is the life of author plus 70 years. So it lasts for a long, long time. Then you have trademarks, which basically identify source of a product or service. So things like Nike brand or Coca-Cola, those are protected by trademarks. Trade secrets are, a lot of companies use trade secrets. It's not really appropriate for open academic environment that universities have, like Stanford, because we don't have physical mechanisms or legal mechanisms to keep things secret. Like, I don't know if you've heard about it, but no one really knows the whole formula, or very few people know the entire formula for Coca-Cola. It's been divided into segments and stored in lock and key so that one team does not know what the other team knows. So it goes in steps. Then you have tangible materials like we talked about, which we really don't need to protect by patent, because the companies are willing to pay a lot of money for getting ready-made materials from us, especially if they've been validated, because it would take them a lot of time and money to recreate those materials. So they would rather come to us and license cell lines and mice. All right, so since we're focusing primarily on patent, what is patent? So I think I already talked about that it provides legal protection for an invention. The important thing to know about is it's a right to exclude others. It's not a right to use. So yes, you can own a patent. So let's say one of you discovers a new use for a drug, and a drug company has a patent right for the composition of matter. You cannot just go and commercialize your new use, because in order for someone to commercialize that, you need to have the license to the drug itself. So that's why you need freedom to operate. That you would hear that word around a lot if you're talking about patents. What is the term of a patent? It's 20 years from the date of filing. And the patents, the reason they're very expensive are because they're country specific. So a US patent is only useful for US. Any company outside of US could use those rights without infringing our patent rights, because we only filed in US. But drug companies or generally big companies would file patents worldwide, and there are lots of mechanisms available for doing that. Next. So next one. Yeah. So you can't file on everything that you think is an invention. There are laws that define what is patentable. So what is patentable is anything that you create that is new and useful. It can be a process, it can be a machine, it can be an article of manufacture, it can be composition of matter, or improvements or new uses thereof. What you can't patent is laws of nature, natural phenomena, abstract ideas. And okay, so now you know what is eligible for patent, but what are the requirements for patentability? In order for you to get a patent, the patent has to be useful, novel, non-obvious over what's available already in the literature. And you have to provide a written description in a way so that someone else who's skilled in your art can actually go and reproduce that. So you can't keep things secret. So the whole idea of patent is to create a cycle where, let's say, person A is teaching person B about a big concept, and person B takes that and further develops it and develops something new. So that there's a constant improvement and innovation. So that's why you have to disclose your invention in the patent fully for others to be able to use it. Of course, you have a limited monopoly over it for commercialization for 20 years, but after 20 years, it's in public domain. Anybody can use it. And I just added these numbers. You don't have to remember them, but most of the times when you would talk to patent attorneys, they would say, oh, we got 101 rejection or 103, 102 rejections. So these are the rejections from patent office, which always come in the first office action, are primarily related to these requirements for the patentability. And I think I'll stress it again more, but I just want to stress one more time here that because the invention has to be novel, if you've talked about it before you file a patent application, in US, you could still get a patent for a year, and we'll talk about that, but you lose all foreign patent rights. So we always say that don't talk to people outside of Stanford, come to our office, tell us what you want to do, and we can help you with still being able to talk about the invention, but in a way that's not going to adversely affect your patent rights. Next slide. So we'll go into more details here, why it's so important for you to keep track of public disclosures. I like to call it bar date because it basically bars you from filing patent application from that date onwards. So the public disclosure can be in any form. It can be a publication, presentation, poster, abstracts, website postings, thesis, submission to the libraries, conversation with outside parties, YouTube videos, bio archives, posters in the hallway. There was a case where someone had a poster in the hallway that was accessible to anyone that could come in and look at that poster. And there was a big debate about whether that would be considered public disclosure. And I think it was, because anybody could walk in and look at that poster. Also, if you sell the invention or offer to sell the invention or publicly use the invention, then it can create the patent bar. Also, if you're doing a clinical trial and you're telling patients about your invention, but it's outside of the context of research, then it can be considered a public disclosure. So a patent application must be filed within 1 year in the US, and pretty much outside, there's no more patent rights left. And a few years ago, US actually changed to first to file, which means that, let's say, person A invents an invention, does not file. In the meantime, person B independently invents the same invention and files. Person B would get the patent, not person A. US used to have first to invent system before, but rest of the world had first to file, and then US changed to first to file. So now you have to be first to file. So that's why it's really, really important. And I put that in red at the bottom. Sorry for misspelling here. But anyway, you have to come to us and talk to us, and do not talk to anyone outside of Stanford without putting a CDA or an NDA in place. And also consult with your team members, because you may not think that an invention is important, but maybe your team members or your PI have a different point of view. So make sure that your team knows what your plans are if you are going to present something outside of Stanford. Make sure that you come back and talk to the team, talk to OTL, give us a call anytime, and that would protect the patent rights for your entire team, because usually it's a joint invention for more than one person. Next slide. Who is an inventor? So inventorship is not the same as authorship. It's actually a legal determination. And if you write incorrect inventors, the patent can be invalidated. So that's why it's important. And if there's ever a doubt about it, we usually just have the patent attorney do the inventorship analysis. In order for someone to be considered an inventor, they must have made an intellectual contribution, either solely or jointly with somebody else, to at least one element of a claim in the patent. We're not going to go into details of how a patent is structured today because of time constraint, but claims of the patent are the most important things. You can write your patent application 100 pages and you can put so many ideas in there. It doesn't matter. Your claims are what define the scope of your patent. So if you want to go after someone for infringing your patent, it's based on the claims. So in order for you to be considered an inventor, you have to have had made a contribution to at least one of that claims. So ownership of patent then is vested equally among the inventors. So let's say one person contributed to one claim in the patent application and the other person contributed to 10 claims out of total 11 claims. Both of them equally own the patent. So that is important for you to know. Each person can do whatever they want, but we would go through what your responsibilities as Stanford employee are, but usually inventors equally own the patent regardless of contribution. Any questions, or should we move on? All right, next, we're going to move on to Stanford IP policy. And I just want to let you know that this is not unique for Stanford. It's pretty much standard for all universities, that if you create an invention using university resources or in the course of your Stanford responsibilities, then usually the invention and the copyright belongs to the university. All of us, including us who do not do research, all Stanford employees are required to sign an SU-18 form, and all of you should have signed an SU-18 form. By signing that, you're hereby assigning all your rights in any invention to Stanford, as well as any copyright. And if you have any questions about whether I own it, whether I don't own it, just contact your office. But generally, if you're using university resources, if you're using funding from a sponsored research proposal or government funding, it would belong to Stanford. Next. And why do we take ownership? Because of our obligations, primarily to sponsors. Because even when government gives us funding for doing research, it's not without any strings. We have obligations to report all the inventions to the government. We need to either file a patent application or release the rights to the government. And then the government receives a non-exclusive license to those inventions to practice on behalf of the United States. And this was Bayh-Dole Act. Again, we won't go into the detail, but it was enacted in 1980 because before that, all of the inventions funded through government funding used to belong to the government. But the commercialization wasn't happening very optimally. So this law was enacted by the two senators, Bayh and Dole. After that, universities were allowed to keep ownership of the inventions, provided we file a patent, we do our best to commercialize that, and if we get any licensing income, we have an obligation to share that with the inventors. Then there could be industry-sponsored work. As Ian said, it's usually associated with some obligations. Yes, we always own, we try our best and we always own our inventions and we have the rights to use our research results, but we still have obligations to report those inventions to the sponsor. The sponsor usually also receives a non-exclusive research license, and they also get the first option to an exclusive commercial license. Foundations, they have all kinds of terms in their agreements these days. It's not just, okay, we're giving you money and here you go do your research and commercialize that. That's no longer true, because a lot of foundations are now even run by VCs or mutual or hedge funds managers, and they want to make sure that the returns go back to foundations and the funds are evergreen for continuing to fund the research. So we have much more obligations to foundations as well than when I initially started in this field about 20 years ago. Then we have MTA, as Ian mentioned, we could have obligations to the party that providing us materials. So as you can see, the funders won't give us funding or materials if they didn't know that we had control over the inventions that might arise from that. So it's really important for us to report those. Next. Now the interesting part, what do we do with the licensing revenue once it comes into Stanford? So after 15% deduction, which is to basically support OTL's operations and to reimburse any of our direct expenses, we spent a lot of money on getting patent issued and for patent prosecution. About 60% of those costs are reimbursed by the licensees, but then there's some that we're not able to get reimbursed. So that would be the direct expenses that we would need to, and those are case related. So if we incur expenses for a case and it never gets licensed, we're not going to take the money out of another case. It's case related income that comes in. 50% goes to OTL. After that, 1/3 goes to the inventor, 1/3 goes to the inventor's department, and 1/3 goes to the inventor's school. For equity, after OTL's deduction, inventors also receive 1/3 of equity upfront from the company. We usually tell the company to directly issue the stocks to the inventors. Unless there's an agreement amongst inventors and we're told about it, all the inventors get equal share of the income. And if there are multiple dockets in a license, we usually distribute the income equally across the dockets, unless there's a specific reason for not doing that. Next slide. So I'm going to be very brief about licensing today, given the time that we have left. But if you were interested in learning more details about licensing, we'll be happy to come back and do one specific talk on licensing only, so you can understand how we choose a licensee, how we make a licensing decision, what do we look for a license in a licensee, and what are the terms of the license, and what type of income do we get under license, and what is the time frame for that. But I just wanted to say that first of all, we really want to do what is best for the technology. That is the main thought we have in deciding which company will be best. Sometimes it's a big company that can throw in a lot of resources behind a technology, or maybe the company already has an infrastructure in place, and they can just, with minimal efforts, can develop our technology. On the other hand, it could be a very new technology and maybe too early for the marketplace, and we have a really passionate entrepreneurial inventor who wants to start a company around that, then we would work with a startup. But next we want to know, can we go to the next slide? Sorry. Yeah. So it's a long process. Getting to a license from discovery, there are several steps involved in there. So we get the invention report, then we have file a patent analysis, we do commercial analysis, file a patent, marketing, I think negotiation, close, we went through that. But each of these steps has several different considerations that we have to take. And finally, we would be in a place where we have a license. And once the license is in place, we also then have to monitor the licensee to make sure that they are diligently developing the technology and that they're paying all the fees that are due under the license. So all those things involve a lot of monitoring on behalf of our business, on behalf of our accounting office. Next slide. So I want to set the expectations that the net conversion from disclosure to licenses is about 20%. And it's true of pretty much, if you were to combine all the data from, let's say, 100 universities, you would still come up with the same number. So we got 500 disclosures, about 250 we would file on, and out of that we would do about 100 licenses. Next slide. And it's also evident from, this is actually for Stanford, and I was surprised to recently see a graph that was actually a combination of all US universities, and it looks exactly like this. Most of the income, so if you look at, these are Stanford stats. So let's say there were 10,000 invention disclosures, 5,000 patent issues, 2,500 license agreements. Out of that, 77 agreements were generated more than $1 million. Only 3 licenses generated about $100 million plus dollars. So it looks like a very lucrative, that yes, if we do licenses, we'll get a lot of money, but you have to be cautious when you're thinking about it. Most of the money to universities comes from very few blockbusters. Having said that, next slide, Stanford is great at doing what it's doing. And I think partly because of the excellent research that goes on at Stanford and the invention disclosures that we received. This is just a stat for us for fiscal year 2020. So you can see that there's a slight discrepancy here, but we're pretty close, 114, 119 million. I think I said something close to that. There were 1,008 technologies total that were licensed. And we were getting more than 100,000 royalties on 42 licenses. Yingli, is that true? I'm going to ask Yingli.
Yes. So that means like more than so for that columns that we have more than 1,000 technology that we license and actually have money, and some of them just make more than others, like 100K you have 42 and 1 million for about like 9 technology. And so all in all, just like it's numbers game. So we never know which one will make money, which one won't. So that's kind of like what Sunita mentioned earlier.
Yeah. I think that's all we had for today. We would be happy to take any questions if there were any. We wanted to take some time to answer any questions you might have.
What is the best way to learn how to write a patent?
I wish I was able to do that after 20 years. No, we don't. We actually don't write the patents ourselves. We work with outside patent counsels to draft the patents, because it has to be really drafted according to the specifications, and you have to write claims in a specific way. If you use comprising versus consisting, they have different meanings, even though we might not think there are different meanings. So it's much better to work with a professional patent attorney or a patent agent who've gone through all the education that's required, have passed the patent bar, and then can write the patent. But you could take patent bar. There's definitely US Patent Office actually has the manual for patent examiners that describes how they examine the patent and how each term is defined. So there are ways of learning how to write a patent. And I know the patent bar, you can pass that. You just need to have a science degree. You do not need JD to do that. And once you pass the patent bar, that's where you learn how to write patents.
Sunita, you had mentioned sort of what is the claim. How do you define what is the claim on a patent?
So I think it defines what is it that exactly you're claiming. So for example, if you had, let's say, you discovered a new molecule, right? So do you have a family of molecules? Do you have the backbone structure that you're trying to claim, or is it just one molecule? So it would start with a broad claim that we are claiming whatever chemical structure that you have. And then you would put some narrow claims under that a structure that can have an R of this. And then you would say a structure that has use for treating a certain disease. And then you would say broad diseases. And then you could say narrow diseases. So the claims can be they're really dependent on what your invention is.
And can you patent a methodology?
Yeah, you can patent a method. It's hard to enforce. So whenever we are trying to look at what we are patenting, we're trying to see how easy it is for us to figure out that someone else is practicing your technology. As I said before, it's a right to exclude others, right? So if you want to file patent, you want to file patent so that people would actually license that technology from before they use it. So let's say if you had a protocol that was a method, like you said, that was generally for producing a vector in a lab, but it didn't leave any fingerprint in the final product, right? So how would you know that someone's practicing that in-house? Because once your patent publishes, or if you publish it in a publication, people can do it. So unless you had some really proprietary materials that go with it, that a company would need to form a kit to sell that to someone who's practicing that method, or if there were fingerprints from that you could somehow find in the final product, those would be really hard to enforce. You can file them on a method.
Thank you.
I have a question about the role of residents and fellows. And specifically, are they asked to complete that form that faculty are asked about disclosing any conflicts of interest, et cetera?
I am pretty sure they do. Lisa, do you know?
I think it depends. I think for fellows, yes, because I believe they have appointments under School of Medicine and not necessarily just Stanford Healthcare. I know if, some clinicians are solely employed by Stanford Healthcare and not Stanford University. So there is a distinction between those, but I'm sure there's something similar, particularly since there are other just IP obligations, but if you are a Stanford postdoc, then for sure you would have signed it. You can also check yourself if you are a Stanford employee under in Access. There is the My Access portion on the left-hand side. There's all of like your tax withholdings. They say you've signed this and whatnot. If you scroll down, there's something called compliance, and it'll tell you if you signed it. But that's how Stanford ensures that we can we have the right to license the IP that you develop, and it's because you are also taking advantage of Stanford resources. That's why this happens.
Thank you. Yeah, I think it's come up. I oversee our pediatrics residency program, and we've had a couple of residents, so they are employed by the hospital, and they've wanted to do some consulting with industry or technology companies. And so it's not technically part of their Stanford work, but it's a little hard to know, are there any things they need to be reporting to the hospital or to the university? So if you have any guidance on that, that would be much appreciated.
Yeah, we can send you a link about the IP policy, but it's actually pretty generous, and it does say that use of university resources, incidental use of university resources, is what is the critical statement.
And there's also, oh, sorry.
Go ahead, Ian.
And there's also a consulting policy in the research policy handbook as well, that I think can provide some additional guidance on how much time can be spent on outside consulting, and also some of the requirements for any outside consulting agreements. I can look for the number, but if you've used okay.
I haven't seen that. That would be very helpful. But I also, is that specific for university employees, or would that also apply to residents who are employed by the hospital?
I don't think we can speak to the hospital. I don't know how that is set up.
Okay.
So
thank you.
Sorry about that.
That's okay.
Great. So I think OTL, I put the website, it's otl.stanford.edu. All of our contact information is on that website. So if you have any questions, or if you wanted to learn about any more topics in detail, just feel free to contact us. Hopefully we can do that in person sometime.
Well, thank you, Sunita, Lisa, and Ian for being here with us today. Oh, and thanks, Ian, for putting the policy in the chat. We really appreciate your time and helping to educate us more about these important topics. So thank you.
And thank you for spending your time with us.
The preceding program is copyrighted by the Board of Trustees of the Leland Stanford Junior University. Please visit us at med.stanford.edu.